Good morning or afternoon, depending on where you may be. We appreciate you holding, and welcome to today's Cloud Services Community Webinar. Our topic for today is Navigating Legal Issues with Your Cloud Practice, a second look. All phone lines are currently in a listen-only mode, and later there will be a question and answer session with instructions being given at that time. You may also ask a question at any time using the chat window located in the control panel. Chat questions will be answered at the end of the presentation with the rest of the Q&A portion. Today's session is being recorded, and you will be provided a copy of today's materials, including the recording and slides, following the call. Now I'd like to introduce our expert speaker for today's webinar. Mark Del Bianco is the principal of the Law Office of Mark C. Del Bianco, located in the Washington, D.C. area. His practice focuses on U.S. and international clients that are using new technologies to provide innovative communications products and services, including fiber networks, competitive broadband service providers, satellite resellers, data centers, and telecom agents. Most recently, his client projects have focused on the legal issues arising from the move to the cloud, particularly issues around data privacy, data security, SLAs, and new cloud business models. Prior to opening his own practice in 2003, Mr. Del Bianco spent 11 years in the Washington, D.C. office of Skadden, Arps, Slate, Mager, and Flom, LLC. His legal experience also includes 3 years in the Antitrust Division of the U.S. Justice Department. He is a Phi Beta Kappa graduate of the University of Maryland and the Yale Law School. Mark, welcome, and go ahead and take it away.
Thanks, Sam. Today is, as Sam mentioned, part 2 of a series on legal issues arising from cloud services. The first part, which is available on the web, excuse me, the website of the Cloud Services Community, down there at the bottom is the URL, covered a large number of commission-related issues that arise for channel partners and agents as they begin selling cloud services. Today, I'm going to discuss one additional issue that arises from the referral or the agent model, and then several risks and issues that occur when you're acting as a reseller or a managed services provider. The first issue, which is the agent VAR partnering issues on the slide, it exists because of the convergence of the traditionally separate telecom and IT indirect sales channels. As any of you that are in either of these channels know, the convergence is occurring quickly because of the move to the cloud by customers, not just the large enterprise customers, but smaller, medium, and small business customers. Now, many IT value-added resellers and many telecom agents are being encouraged or are choosing to work with each other to bring their different skill sets together in order to make sales in the new cloud environment. So what are the risks of partnering with other agents and VARs? And I'll talk about how a partner can protect itself in that type of situation, or at least the issues that you should be thinking about as you consider whether you want to enter into those types of relationships. The second issue is that I'll be addressing is the new risks that are involved in reselling or being an MSP for cloud services that are different from those involved in just being an agent or even in some cases a reseller for telecom services. I'll also touch on how a partner can maximize its ability to move a customer and minimize the risk of losing a customer if the cloud provider that you've recommended or resold doesn't perform. This risk is not limited to cloud services, but the fact is that unlike most telecom services, the cloud services are also new, that there's a lot of uncertainty about both what the customer should expect or does expect and what the actual performance will be. The next issue that I'll address will be SLAs and whether and how they should be negotiated. And then finally, I'll take a quick look at cyber liability insurance and how it can reduce some of the risks that I will be talking about. So let's start with number one. What are the risks of partnering with other agents and VARs, and how do you protect yourself? Now, most master agents, many of you may be involved with master agents and cloud service providers that are offering partnering programs that match VARs and telecom agents. If you're approached about participating in these programs, you need to read the fine print very carefully. The programs should address all the key issues I've listed here, but sometimes they don't, and many don't, is what I'm being told. And if they don't, or if an agent and a VAR are operating informally on their own outside of one of those programs, if you don't consider these issues and address them up front, the results can be disastrous. I actually had this brought home to me recently when I was consulted by a channel partner that had an informal agreement with a VAR to work on deals and get a commission split. And what happened was they had a fairly decently papered agreement, but the agent had not examined or looked at the underlying agreements. And when the VAR owner died unexpectedly, under several of his agreements, the passing of the business to his heirs was considered a change of control, and the VAR's commissions and the agreements themselves were terminated for cause. Now that's a kind of a draconian provision, and I don't see that very often, but that's what this VAR had, and so the VAR's commissions were cut off, and the partner who had been working with him was also cut off. And when he came to me and asked what he could do, after looking at the situation in the documents, I told him unfortunately there was very little he could do in that case. So what are the issues that you need to be thinking about if you're going into a partnering situation? The rules of engagement, whether they're being imposed by a master agent or a service provider, or whether they are being negotiated between you and your VAR partner, or if you're a VAR, your channel partner, should cover at least who's the lead, what is each party going to be expected to do, how is the commission split fixed, and is it going to be fixed for each deal separately, or will it be a permanent split? You also need to look at the assignment and change of control clauses, as I just mentioned in that example. And then I'm going to talk to you about step-in rights also. If you're not the lead, you really need to be, first of all, reviewing your partner's contract with the service provider or master agent in order to understand your partner's rights and duties, because your rights and duties are never going to be, your rights are never going to be any greater than whatever the rights of your partner who has the direct relationship are. And so in particular, you should understand the assignment and change of control clauses. And here the reason is simple. If those clauses are not favorable, it may be easy for the master agent or the service provider to terminate the commissions in the event of a sale of your partner's business or even the death of your partner. And you will be collateral damage in that situation. That's exactly what happened in the example that I mentioned a moment ago. The passing to the heirs of the business constituted a change of control under the service provider agreements, and the providers were able to terminate commissions. The agent was just out of luck. There was no independent right on his part to commissions on the joint deals. Now, one way to deal with this type of a situation is to include what are called step-in rights in the service provider agreement or the agent agreement. Step-in rights may be a familiar concept to some of you, but they're a relatively simple concept. If for some reason the lead VAR or the lead channel partner on a partnership is unable or unwilling to fulfill its contractual obligations, the agent partner can step in and simply perform the duties that would otherwise have been performed by the lead VAR. Now, obviously, step-in rights can flow the other way if the lead is the telecom agent and the VAR wants to be able to protect himself or itself. Now, I'd expect that where a master service, a service provider or a master agent is encouraging or forcing these types of partnerships, that the provisions of their agreements would cover this. But as far as I can tell from scuttlebutt, that's not always the case. And you really should be prepared to demand step-in rights if necessary, so that you don't lose your right to commission in the event that a partner somehow changes or fails to uphold its obligations. That one is the only issue I'm going to talk about today that really relates directly to the agent model. There are other risks that are involved in moving to the resale and the MSP model for cloud services, and those are going to be the focus of the rest of my talk today. Some of this will apply to the agent model, but the risks and the issues are much more important in the resale and the MSP models. The three key issues, are ensuring payment, the potential liability and other issues around data security and data breaches, and then the liability for service provider failure on the part of the reseller or the MSP. So you can't eliminate any of these risks, but I'll talk for a few moments about how you can put language in your agreements to minimize these risks. The first one is familiar. Everybody knows there are risks in any business that you're not going to get paid, but there are additional ways and reasons why you might not be paid when you're reselling or offering managed services, as opposed to when you're simply acting as a referral agent. Now, one issue that I'm seeing these days that raises that risk is that many cloud resale arrangements are being structured as what I would call a triangular deal, where you as the reseller have an agreement with the master service provider or the master agent, and the service provider has a separate agreement with the end user. Now, I understand people are trying to do this in order to limit some of their other liability, but what often happens in these situations, and there are two variations, but what often happens is that the service provider bills the end user for the retail price of the service, and the end user pays the service provider, and then the service provider rebates or sends to the reseller the difference between the reseller's wholesale price that it's being charged and the retail revenues that the service provider received. So in this situation, you have two risks of non-payment. You have the risk that for some reason the customer will decide not to pay or will be unable to pay the service provider for the services. And then you have the risk of delay or non-payment by the service provider to you of what you've actually earned under the agreement. Now, the resale situation, as all of you that have entered into it or looked at it know, creates a much higher level of risk on customer non-payment, because you as the reseller are generally on the hook for payment of your wholesale price, whether or not you are paid or whether or not the customer pays the service provider directly. So it's holding the paper is definitely riskier. And one way to ameliorate the problem is to negotiate a clause that basically allows you to get out of the arrangement if you need to, in the event that individual customers become dissatisfied and the service provider allows you to move them. This type of clause is obviously something that you want to have if you can, but the service providers are not real happy about it. So I want to talk briefly, well, not so briefly actually, I want to focus on the issues of data protection and security, because those are the issues that really differentiate cloud services and the risks involved in it from traditional telecom services or from traditional IT sales and managed services provided by IT VARs. So the issues of data protection and data security are really hardly on the radar for most telecom agents and VARs until they begin to move to cloud services. There are obvious reasons for this. The risk of substantial data loss is so small in telecom services because in general there's no data storage. Everything is transient, just going over the fiber or the wire or the satellite connection. Excuse me. If there's an outage, the data is generally still stored somewhere, and if it's not, the data owner's network quickly recognizes the outage and sends data via an alternative route or stores it for later transmission. So either way, the customer has and it can use its own data. Moreover, most in the telecom area, most contracts, and certainly all common carrier tariffs, give the carrier absolute immunity from lawsuits for what are called consequential damages, which are the damages that arise, the business damages or other damages that arise from an outage or a failure to provide the contracted service. So in the telecom space, the loss of data or the inability to access it is not a very large issue. It doesn't matter whether the partner is acting as an agent or a reseller. Now, cloud services are a whole different ballgame. The ability to store and manipulate data off-site is a key feature that attracts customers to cloud services. The data retention, unlike telecom, is not transient, but it's intentional and it's long-term. And so when you're comparing cloud services to analyze the risk and determine which ones you want to resell, you need to consider a variety of factors. Obviously, what are the service levels offered, including the uptime, the availability, the data backup, and the mean time to repair. From the point of view of a reseller or an MSP, you really need to understand what the provider is going to indemnify you for in relation to data breaches and data security. The issues and the costs around data breaches and data security are growing almost daily. I mean, all of you, I'm sure, are familiar with the Target situation, which was a months-long data breach, led to tens of millions of individuals' records being taken, ended up with Target estimating its costs, I believe, at $100 million and counting, just in direct costs, and has led to the firing of, or the end of the career of the CEO and the CIO at Target. And I want to stress here that the Target is the poster child here. If I were giving this talk 6 months from now, Home Depot might be the poster child. We're all waiting to see how that situation develops. But it's not just large companies that are targeted. I've seen statistics that show that 31% of the data breach attacks in the U.S. over the last couple of years have been to businesses with less than 200 employees. So you need to be very aware that even if you're selling to small and medium businesses, there may be opportunities, there may be people out there that are willing and able to hack in and look for their data and steal their data, which, if that happens, can leave you and your service provider in a very difficult situation. You need to understand those risks. One of the other data points I'd like to bring up is that the cost, even if you have very little litigation and no actual damages liability, the estimated cost per lost record in a data breach right now is about $188 per record. That includes all the costs around notifying customers of a breach, of providing credit monitoring if that becomes necessary, of working with regulators to report the breach and law enforcement to deal with it if necessary. So even if your customer only has 2,000 customers of its own whose data it's keeping and whose data is lost, you could be looking at a $375,000 bill just to handle the data breach. That doesn't count any costs you might have from litigation over responsibility or for actual damages to the or losses by any of the customers if their data is misused in a way that harms them. So you may be thinking, well, this isn't my issue, but it really is, and you need to think very carefully about how you're going to protect yourself in the event that your selected service provider has a breach. Obviously, my recommendation would be to get as strong an indemnification clause as you can from your service provider, and now they'll undoubtedly try to cap both their liability and whatever remedies you seek, but at some point you have to ask yourself if the proposed limits that they are offering are reasonable, or if you would just be too exposed. I mean, for many of the agents in the channel and the VARs, even getting involved in a data breach litigation, much less having any actual damages or having to pay for the costs of notification and so on that I've just discussed, could be devastating to your business. So you really need upfront to understand what the security procedures are that your provider's using and what guarantees they're willing to give you about not being liable for in the middle. And again, even if you get good indemnification and you get good limitations of liability from your provider, there is nothing that is necessarily going to stop the end user customer from suing you and including you in any lawsuit against the provider. Now, you'd also, I think, want to I don't mean, moving back there for a second, I don't mean to sound too negative about the risk, but it is something that you need to go into with your eyes wide open, because it is substantially different from the situation that VARs and channel partners have been looking at in their respective verticals for the last 20 years. And it is an area of law right now that is in great flux, and there are a lot of lawsuits floating around that, a couple of years from now the law may be clearer, but right now it's kind of a murky situation and nobody's quite sure what the liabilities might be. On a related issue, the third issue that I've identified here is the liability for service failures. And again, that is very much related to the data breach issues. And there's the separate issue of whether they're living up to the other parts of their SLAs. I'd like to talk briefly about how you can minimize the risk of a customer basically walking away, you losing the customer if your cloud service provider doesn't perform. We all know this is a risk. It starts with the provisioning at the very beginning, goes through the service. Problems can arise anytime. In this way, the cloud services are not really a lot different from the telecom services that have traditionally been sold by the channel. But what you're finding as you look at these agreements and you look at possible arrangements is that most of the cloud services provider contracts include some form of a non-compete and customer non-solicitation clause. So in general, these would limit your ability to move your customers even if the service provider fails to perform up to its SLAs or has some sort of real security breach issue. So at the beginning, you really need to push back and make sure that you and your customers have the right to terminate their services in the event of a chronic failure to perform or repeated outages. And I want to emphasize something here. It's not just your customers that need to have the right to terminate. You need to have the right to terminate, at least in part, your purchase of services under your agreement. Otherwise, when you're the reseller, your customer could terminate and walk away, but if you haven't got a concomitant right to terminate, you could still be on the hook for the services, the wholesale price of the services that customer was purchasing. So you need to make sure that your provisions and your customers are aligned and allow you to get out of the wholesale operation if the customers are terminating for a cause on the retail side. One of the other things that you need to think about in that same type of situation is that if you have a customer non-solicitation or non-compete clause that is too strict on you, you might place yourself in violation of your agreement with the reseller by helping that customer to move. In other words, just because they have the right to terminate and move somewhere else doesn't necessarily mean that you have the right to help them terminate or move somewhere else. And it's a tricky concept, but I've seen in a number of service provider agreements, they basically try to make it so difficult for you to help your customer that even if the customer terminates, you lose the customer because you can't help them and be involved in their move to another service provider. So you need to be aware of that at the very beginning so that you can deal with it. Otherwise, it could come back to bite you. I've talked about the SLAs, and I know that most of you are familiar with SLAs. You've probably dealt with them to different degrees. Certainly those that have the resale model have dealt with them a lot more than those that have the referral or straight agent model. The main purpose of the SLA is to assure the customer that you can rely on the cloud service even in mission critical areas, and then to provide appropriate remedies if the provider fails to meet the promised service levels. So if you've got a well-designed SLA, it'll provide agreed-upon benchmarks and then incentives, hopefully, that encourage the provider to be diligent in addressing issues that come up and resolving those issues so that the service is provided to the customer. Now, the specifics vary for every provider and every type of service, but most cloud services SLAs and most managed services SLAs cover at a minimum the following areas. First, service uptime, then problem response time and resolution time, service response time, remedies, and Now in the cloud, I'm also seeing a lot of SLAs that cover the timing, the ownership, and then the timing and return of customer data, so that if there are problems, customers can get access to their data immediately to transfer it to another service provider and obtain their services, or to bring it in-house, because frankly there are a number of instances these days where an attempt to customers are attempting to move part of their work to the cloud, and they decide it doesn't work out, and they start to bring it back in-house. Now, the larger cloud providers, I'm going to talk briefly about SLAs and negotiating SLAs. The larger cloud providers generally limit their SLAs to 5 or 10 key performance indicators, which they select. And there often is not a lot of flexibility in negotiating those SLAs. But SLAs can be highly negotiable if they're willing to, if the customer is willing to adjust the pricing, and that's the key. The more you pay, the better performance you're going to be guaranteed. So, but if a customer is not willing to pay substantially more for a better SLA, it's going to be much harder to negotiate SLAs that differ greatly from what the standard offering of that service provider is. One thing I will say is I've seen that negotiation of SLAs is more fruitful with smaller cloud services providers, because they are hungrier for the business and more willing to provide a higher level of service than the larger providers. I will say SLAs and remedies are obviously more important in contracts that either have minimum purchase requirements or that have terms of 6 months or more. When the services are just purchased on a month-to-month or an as-needed basis, the SLAs are less crucial, because if the customer is dissatisfied, it can quickly and relatively easily move its operations and its data somewhere else. So one thing I would say is that a partner that's just acting as an agent or a referral party should rarely, if ever, become involved in negotiation of SLAs for one of its customers. There's no real business upside to it. If you are able to negotiate a better SLA, that's great, but it's not very likely, because frequently the partner will lack the technical expertise to negotiate an improved SLA. And if you negotiate a better SLA and the service provider doesn't meet it, in your customer's eyes, you are going to be tied very closely to the service provider and tarred with its failures. So from my point of view, I've generally advised clients who are using the the referral model, and not to get involved in SLAs at all, other than perhaps at the initial stage when they're comparing services for the customer, to look and make sure that the SLAs are relatively comparable. Excuse me. Now, by contrast, an MSP partner, and by managed services managed services provider partner, I mean one that offers generally what could be considered outsourced IT services, such as network monitoring, remote hardware repair, or software updating, that it's doing with its own technicians and engineers. I'm not referring to MSPs that also resell the services of a lot of other cloud services providers. So an MSP partner or an MSP really has to develop its own SLAs for the services that it offers. And the most important metrics tend to be, when you're drafting these, the availability and time to service or time to repair. And by availability, I'm referring to your technicians, engineers, your NOC, if you have one. And the key here is to make it a realistic SLA so that you don't overpromise and you don't underperform, and your customers remain satisfied with whatever services they've purchased from you. The third option, or the third situation in which SLAs become important, is when a partner is acting as a reseller. And in that situation, you have generally two types of SLA issues. The first involves the SLAs on the resold services. And then if you are either bundling services or white labeling a suite of cloud offerings and adding some secret sauce of your own, then the customers may require you to have your own overarching SLA. The SLA for products that you are just reselling and not adding any value to, you have to be very careful here to make sure that you are not on the hook for anything that your cloud services provider has not agreed to provide to you. So in general, when you're just reselling someone else's service, the best option is obviously to insert an SLA pass-through clause in your customer agreement. So in this type of a clause, the customer just acknowledges that it knows you're a reseller, that you have no control over the quality of service because the network belongs or the service is being provided by someone else, and that you're simply passing through to the customer whatever SLA guarantees and remedies that you have contracted for with the underlying cloud services provider. And again, here you want to have both pass-through and transparency. You want to make sure that your customer understands and agrees. So you may, I've seen this actually sometimes in the agreements, people put it in all caps and bold just to make sure that there's no guarantee still that that a customer that's disgruntled won't come after you for the failure, but at least you've identified the risk and made it clear down the road to a court or a jury, if God forbid that should happen, that you did not make any additional promises beyond what the customer knew it was getting from the cloud services provider. Now, another option that may reduce your risk, both on SLA issues and on data breach issues, is to use the triangular arrangement that I referred to earlier. That is an arrangement where you have a wholesale agreement with a cloud services provider, and you're finding the customers, however, do not sign an agreement directly with you. They sign it with the services provider. That obviously is a more complicated relationship and introduces some other issues, but in theory, and I say in theory, it should keep you as a reseller out of the loop of liability for potentially data breaches and failure to perform. But again, these situations aren't hard and fast. It's not clear what a court would do in that situation, and even if there were a finding that you were not necessarily liable, the cost of getting to that point in litigation could be relatively high for a small or medium-sized channel partner or VAR. So you really want to try and reduce that risk in any way you can. Now, if you're bundling and white labeling a suite of cloud offerings from several different service providers and then adding your own operations center or something else, customers will almost certainly want an SLA that covers all of the services. That's a very difficult negotiation often because you want to minimize your exposure, but at the same time you want to convince the customer that there's a value to the expertise that you're bringing as, say, a network operations operator or a systems integrator. So if you have to provide a general SLA because you are doing that type of an offering, you want to make sure that you address the service credits, that you can live with whatever service credits you're giving, and that the termination rights for chronic outages or failure to meet service levels are not so onerous that or not so easy that you have allowed your customers to walk away in situations where it's really not a material failure. So the last issue that I want to talk about is something that is just coming into focus in a lot of industries, and that's cyber liability insurance. And back in the old day, there were no insurance policies that really focused on all the cyber liability issues. There were general professional liability policies that covered information risk. In the 80s and 90s, even the early part of the aughts, these generally were limited to damages caused by viruses or other damage to your network, loss of data perhaps caused by viruses. But there weren't a lot of other types of risks identified, and there weren't policies available to cover them. Now, obviously, as we've all become aware from reading the newspaper almost every other day, there are a lot of other risks. There's the risk of loss of confidential customer data or patient data if it's in the medical health field, later misuse of that data. There's potential damage to the network, and then for a lot of companies that rely on e-commerce, there's a loss of income if the network goes down, if the business goes down because of hackers or a DDoS attack, or if the data itself is somehow corrupted or unavailable and you can't carry on your business. So businesses are basically clamoring for coverage on cyber liability risks, but they often can't obtain the type of policies that they need. In particular, policies that cover the cost of a data breach are really difficult at this point. The main reason so far is that there's a lack of data about the odds that companies will be breached and what the true costs of the data breaches are. So insurance companies are right now beginning to collect the necessary data from victims and potential victims of breaches. But right now they don't have industry-specific numbers in most areas that would allow them to confidently price cyber liability insurance. Now, the only industry that I think there is enough maturity in the model of security to allow them to price competitively is the electricity generation and distribution sector, which has been focused on by the White House and the Departments of Energy and Homeland Security and the power companies themselves. So there's a lot of data out there. There's very little data on breaches right now at cloud services providers. Most of the breaches, if you look at the information out there, most of the breaches right now are when companies have their own operations in-house. You don't see a lot of breaches at the larger cloud services providers, but there's no reason to think that won't be coming. So you need to think about that as you're looking at whether you want to try and get some sort of cyber liability insurance for your business. The cyber liability insurance that I'm aware of has a variety of sort of different modules that the insurance agents call it. One module will cover privacy liability. Another covers data breach costs. There's one that covers network security. My personal favorite is the one that covers network extortion, and that's for those of you that are familiar with the CryptoLocker malware. That's the type of situation it would cover, where somebody goes in and either encrypts your data and threatens to destroy it or leave it encrypted if you do not pay them a certain amount of money, or they threaten to initiate a DDoS attack or some other kind of penetration and bring down your network if you don't pay them money. And then one last module that is actually offered by some companies is a module that covers the costs of regulatory proceedings. So if you do have a data breach and you get a letter or you get a call from the California Attorney General or the Massachusetts Attorney General and they want to know, you end up spending a lot of time notifying all the Attorney Generals and dealing with their staffs to make sure that all of the state laws are complied with. The insurance will cover that. So the reason that I'm talking about this is twofold. One, so that you can begin to look at it and you may want to bring it to the attention of your customers as they look at what the risks are for them about putting data in the cloud. The other is I expect in the very near future that some of these insurance companies will be developing policies for service providers and resellers of cloud services, and it may be a very cost-effective way for you to minimize some of the risks that we're talking about here, particularly if you can't get the type of contractual provisions that give you some comfort on the risks that have been accepted. So Sam, I'm pretty much covered the things that I wanted to cover. If there are any questions out there, I'm happy to take them.
All right, excellent. Well, thank you, Mark. We will open it up for questions. If you'd like to ask a question, please, we have a couple different ways you can do so. One way is to raise your hand using the raise hand button located in the GoToWebinar control panel. And if at any time your question gets answered, please lower your hand to remove yourself from the queue. And also, if you prefer, you can ask a question via the chat box with the chat window located in the lower right-hand corner of your screen. It looks like we already had a couple coming in. That's great. Mark, this one was from a little bit earlier. Does your firm have a template agreement that covers all the concerns on both webinars for reselling cloud services such as hosted applications and desktops?
The answer to that is no, for a couple of reasons. One, most cloud services resellers, and I tend to represent the resellers, not the larger cloud services companies themselves. They don't have the clout to try and force a reseller, a cloud services provider to use their own template. So what happens is you're almost always, when you're representing a reseller, you're almost always working from the draft that you get from whatever cloud services provider it is. And I can tell you that those vary greatly, both in length and in quality. What we have is basically a sort of a checklist of the issues that we think need to be addressed, and then we sort of go through the agreement and look at that. But it's very difficult to have for a smaller channel partner or VAR to have its own agreement that anybody will agree to.
Okay. Thank you, Mark. Another question. How common is it for an SLA to provide uptime exemptions for security reasons? Example, an automatically updated vendor security patch affected service.
I'm not sure. Could you read that again, Sam? I think I understand the question, but I just want to make sure.
Yep, sure. It's how common is it for an SLA to provide uptime exemptions for security reasons? And the example he gives is an automatically updated vendor security patch affected service.
It is not very, it's very common for an uptime guarantee to have an exemption for scheduled network maintenance, which could include security patches. I have not seen, and I certainly would push back very hard, whether I was representing a reseller or an end user customer. I would push back really hard against an exemption for downtime that was caused because the security patch didn't work right or knocked out part of the network or something, which I think is what that was addressing. It's there are so many situations recently where a patch or an update or whatever has caused problems that reverberate across an entire network, that you would not want to allow such an agreement, such an exemption, and I've not seen any exemption other than for the actual pre-scheduled time that the service provider has notified everyone of in advance.
Okay, great. This question actually goes back to the first one. This was from Juan Trevino. His question, I guess, was actually for his customer, not for vendors. So I think what you might be looking for is if you have a template, or maybe do you know a place where a resource where folks can look for a possible agreement template for their customers for things like this?
I don't.
Okay.
Sorry about that. I mean, lawyers that practice in this area have their own clauses and so on, but I'm not aware of any publicly available templates. That's maybe something the cloud services community should be looking at.
Yeah, no, it's definitely something we could start poking around for. Another question, are there models available for teaming agreements between VARs and channel partners?
That is an excellent question. I, again, am not aware of any, and I have not actually, I've looked at a couple, but not really had to do anything too much. I have not looked at any of the programs that Intelisys or Telarus or any of those large master agents are imposing or requesting their partners to participate in. And so I don't know that there are any out there.
Okay. Another one, what do I do if my VAR teaming partners agreements, hold on a second, what do I do if my VAR teaming partners agreements with a service provider or master agent don't provide the kinds of protections for me that you talked about?
You basically have two options. You can measure the risk and decide to stay or walk away, or you can explain the issues to your partner and see if jointly you can go to the service providers whose agreements are problematic, or the master agent whose agreement is problematic, and explain the problem and maybe negotiate an amendment. But unless you've got a lot of business to dangle in front of them, I think it would be a very difficult sell. And so probably you're back to figuring out whether you want to accept the risk.
Excellent. Are there ways for a reseller to avoid liability for data breaches on a service provider's network?
I touched on that a little bit, and the answer is everybody's trying and nobody knows if any of the options will work. And again, as I've said, if you avoid liability, you may still be dragged into litigation and have all the litigation costs, and that's what you need to be thinking about.
Okay. Can you talk about selling to industry verticals that have particularly stringent data protection rules, such as healthcare and financial services?
Wow. That is a whole nother webinar, I think. I will just say briefly that if your end user customers are going to be in those fields, even a minority of them, you need to be very careful. First of all, it's not clear, for example, that you can contract away your potential liability or your obligations under HIPAA, which is the Healthcare Act that governs all of the data security and data privacy in the health area. So it may be much more difficult to get out of that. You may be subject to those, and those can be very expensive and time-consuming to comply with. If you are going to go into those verticals, you want to investigate with the cloud service providers whom you will be reselling to make sure that they have all the certifications and other agreements that they need to have in place, because those two, particularly finance and healthcare, are very intensive in terms of resources. And for example, I have a client that's a data center that was looking to sign some agreements with health care providers, and when we looked at what would be involved and how they would have had to upgrade the physical security, the network administration, and so on of the data center, it turned out to just not be worth it, because the cost would have been much more than they could have gotten from going into that vertical. You really need to find partners that are cloud service providers that specialize in those verticals if you're going to look at that.
Okay, excellent. Are there different rules if my customer is using the cloud services to store and manipulate data from places other than the U.S., for example, like the European Union?
Yes, and again, that's probably definitely a whole nother webinar. But this is, I guess, this and the previous question are sort of a know your customers pitch. If you are selling to end users who are storing, manipulating data from EU individuals or EU companies, you're going to be covered, and they're going to be covered by a whole additional set of rules, even if the data is all manipulated and stored in the U.S. So you want to make sure, as you're doing your due diligence on potential customers, that you understand where their data is coming from, whose data it is, and what laws apply. And again, this is the type of situation where you would want to work with service providers, probably that have data centers in the EU in that type of a situation, but also at the very least, if they are storing data, if the end user customer is storing EU data in the US, you want to be working with a cloud services provider that is familiar with and compliant with all the EU safe harbor rules and so on.
Excellent. Well, that appears to be all the questions we have, Mark. So I want to thank you for your time and for sharing your knowledge with us today.
Okay, thank you, and thank all those who attended.
Yeah, definitely. Thank you again, everyone else, for attending again. And please do take a few minutes to fill out your post-event survey. We value your input very much, and use that to shape future events. But at this time, this concludes today's conference, and you may now disconnect.